Hey. Hi, how's it going? I'm here to debate the travel ban, argue it's unconstitutional. I'll make for three basic arguments. One is that it violates the, I don't know why I'm getting feedback. I'm going to argue it violates the Immigration and Nationality Act. The Immigration and Nationality Act was revised in 1965 to eliminate quotas and reduce discrimination in immigration. And that was its purpose, to reduce discrimination based on national origin. And the travel ban discriminates based on national origin, blocking immigration from certain countries. The second argument I'll make is that it is unconstitutional, which is different from my legislative argument. I'd point out that I'll make an argument that it is driven by animus, opposition towards Muslims, that Trump has run on a campaign that was very anti-Islamic. He supported shutting down mosques, surveilling mosques. In April of 2011, he said we have a substantial Muslim problem. In September of 15, in December of 2015, he said we had a massive Muslim problem. In March of 2016, he said refugees hate us and are trying to kill our children. As soon as the London terrorist attack happened, he said that was a rationale, a reason to support the travel ban, which means he's very anti-Islamic. This supports anti-Islamic discrimination in the United States, which is a violation of the Equal Protection Clause. The travel ban also discriminates people's rights to familial relationships with other people. If somebody's dying, it's hard for a family member to get into the United States, for example. It also undermines people's economic rights, particularly states' rights to have tourism in their states, to employ people in their universities. It threatens the health of Americans. Over 14 million doctors are from other countries that the travel ban is impacted. It also, kind of on a third point, arguably violates international law. The United States is a party to the International Convention on the Prevention of Discrimination, and once we're a party to it, it's binding on the United States. It's part of our law, and the ban is discriminatory. So those are my three basic arguments. It's inconsistent with the Immigration and Nationality Act, and it's unconstitutional, and it violates international.
All right. Well, thank you. Good evening. First of all, thank you for taking on the debate. I want to thank the call-out community for hosting this tournament, and thank the audience for watching it live. First of all, I just want to reiterate and make sure that we are debating the same topic, which is Trump's travel ban is unlawful. The unconstitutionality of it has been removed from the topic, from the call-out community. So for this sole purpose, I will not touch base, absolutely not, on the constitutionality of the travel ban, strictly on the statutory law. And for this reason, I will demonstrate that this travel ban is not unlawful, but within the confine of the law. And in order to do so, it is very important that the audience understand that we must set aside all feelings and all emotions associated with the travel ban and its application. I'm not debating whether it is morally right or wrong to implement such a document, as my personal feelings have nothing to do with the legality of the travel ban. With that being said, I will provide my fellow competitor and the audience with the legal foundations that will prove that Trump's travel ban is lawful. I will do so by referencing the current statutes of the executive order and argue that the Ninth Circuit Court, who challenges the executive order on statutory ground, is a moot case. And for the legal basis, the Immigration and Nationality Act of 1952 was amended not in 1965, like my opponent said, but in 1968. And it specifically allows the president to suspend a class of aliens from entering the country if he determines they will be detrimental to the US interest. The statutory provision Trump cites as the legal basis in his order, the 8 US Code, paragraph 1182, gives him the legal authority for suspending visas. Reasons for it can include anything from individuals having spreadable diseases to them posing a threat to the American public safety. Similar actions have been taken by previous presidents. For instance, the Chinese Exclusion Act of 1882, which banned Chinese laborers from immigrating to the US amid concerns of unemployment. In 1924, the Johnson-Reed Act was implemented to limit the number of immigrants coming to the US, imposing a quota, at the same time completely barring Asian immigrants.
Okay, so just to make a few points out of the gate, the question of whether or not something is unlawful, the question of constitutionality is relevant to determining whether or not something is unlawful. The Constitution is a law, so if an executive order violates the Constitution, then it is determined to be unlawful. So my arguments there are relevant, but I'm happy to engage more specifically in the Immigration and Nationality Act, if on that topic, which I already brought up. Okay, so maybe it was amended in 1968 instead of 1965. Sure, I'll agree to that. I didn't go back and double check, but sure. The purpose of the Immigration and Nationality Act of 1968, all right, was to prevent exclusions based on national origin, which means that you can't prevent a set of immigrants from a particular country from coming into the United States. This was a reaction against exactly what my opponent has specified, the Chinese Exclusion Act, where they excluded all people from China and sent them back, a policy that has been determined to be racist by the Congress. The whole point was a reaction against this, and reaction against previous court decisions that upheld this, all right, Chinese Exclusion Act as part of the plenary power, which has been diluted in certain Supreme Court cases since the Chinese Review Act was upheld. For example, in Landon v. Placinia in 1982, the Supreme Court affirmed that a resident alien returning from a brief trip abroad must be afforded due process, and this was also kind of emphasized in the Ninth Circuit cases. The Chinese Exclusion Act was a blatantly racist thing, and that was the point of reviewing it. Now, the Immigration and Nationality Act change of 1965 bans based on race, sex, national origin. The examples brought up by my opponent are talking about particular groups of people from particular countries being excluded. Yes, that happened under previous presidents. There was a certain group of Haitians that were determined to be a threat from the United States who were limited from coming, but not everyone from Haiti. That is the distinction. The Immigration and Nationality Act the revision got rid of these national origin discriminations. And even if the president determines a special purpose, which is a purpose under the law, that cannot be held to be under reviewable. Otherwise, the president would just be a tyrant. In other words, the president has to justify it. The president has not been able to justify this ban, and quite honestly, has been losing in court to tangentially related unlawfulity arguments and unconstitutionality arguments because he can't demonstrate any rational basis at all for the act, which I'll be happy to engage in, that this is not a legitimate special circumstance, and this power is reviewable by the courts, which has been established.
Okay, you've been muted. Okay, well, let's back up a little bit. Once again, the constitutionality of the implementation of this act is not in play in this debate. It has been specifically removed from the topic. So now the only constitutional court involved is the Ninth Circuit Court, and there's more to say about that. But to clearly specify the law behind the act. Okay, my opponent mentioned racism. Okay, racism is wrong. It's morally and ethically wrong. Okay, but that's not what the ban is about. That's what people think it is. And even if it was racist, that doesn't make it unlawful. Racism is not illegal. It's immoral, yes. It's unethical, yes, but not illegal. Same thing for the justification. The justification, justifying the ban by itself, doesn't make this ban legal or illegal. the act by itself, the executive order, that's what we need to look at. And that's what I'm focusing on this debate. And clearly, Congress gave 100% authority over immigration to the president. That's the law. They delegated the ability to suspend the entry of any alien into the country, and the executive order falls fully under that statute. So let's take a listen at what the text of the law says, and I quote, "Whenever the president finds that the entry of any aliens or of any class of aliens into the United States will be detrimental to the interests of the United States, he may, by proclamation and for some period as he shall deem necessary, suspend the entry of all aliens or any class of aliens, be they immigrants or non-immigrants, or impose on the entry of aliens any restrictions he may deem appropriate." End quote.
Look, I know you're focusing on that like very specific wording of the law. Okay, but the wording of the law itself does not exist in a vacuum. Okay, the wording of the law and the meaning that that particular phrase of the law has is determined by how it has been interpreted by the courts and the legal history associated with it. First of all, you have to look that there was originally was a 1955, okay, Immigration and Nationality Act, which was revised in this new law to prohibit discrimination based on national origin, which the executive order clearly does by banning a class of immigrants from a particular country. When you look to determine the meaning of a previous piece of legislation, you have to look at the revisions of the legislation, okay? Which means that since the purpose of the legislation, which has been clearly established, okay, in the congressional history, which is relevant to determining what that particular phrase cited means, clearly says that they did this and they supported this law in order to prevent that discrimination based on national origin. So you're kind of ignoring, I think, the context through which the change occurred. Second of all, I've distinguished between the examples that you've given where this has been previously upheld as particular classes of people from a particular country, not every Haitian. None of these examples apply. The Chinese Exclusion Act, which you cited, okay, originally, that was gotten rid of by this that's why this revision to the law was passed, to prohibit this, which proves that this is the purpose of intent of the legislation. Third, every court has agreed that you can't just turn the president into a tyrant. The president gets to do whatever he wants. You keep referencing this language in there that says, yes, the president gets to do it, but under what circumstances? Under special circumstances. The argument is that these are not special because they do not reduce they do not reduce the risk of terrorism, which is kind of a separate debate, but it is relevant because the president must establish the law has a rational basis, that it has some meaning to it because it does violate people's constitutional rights. Article 6 of the Constitution says the Constitution is the supreme law of the land, which means that Congress cannot delegate but constitutional violations to the president, which was why my arguments about the constitutionality are relevant. Your interpretation of what that sentence in the legislation says is inconsistent with the Constitution, and Congress cannot, under interpretations of many Supreme Court cases, cannot just delegate cannot give the president power that he doesn't have under the Constitution. So even if you just ignore all my arguments as to why it's unconstitutional and ignore my argument that the Constitution is a law, the constitutionality of it is relevant to interpreting this particular piece of law.
Well, there's absolutely a need or an interpretation behind this debate, because it determine whether or not the Trump's travel ban is lawful. And you're referencing the wording of the law. And yes, the wording of the law is the law. And if it's legal, then Trump's travel ban is lawful. It's not unlawful. So the law cannot be clearer than that. And whether the feelings and sentiments towards the ban makes it racist, discriminatory towards one race or religion, is first of another debate, but most importantly, does not render this executive order unlawful. So what the viewers need to know is that such a ban, because that's the word that's already that makes that execution order suffers. The ban, such like this, was implemented and done before, another 100 some odd years ago, but in 2008, under Obama's administration. It was not called a travel ban, and it wasn't even revealed to the general public. It's known as CARP, C-A-R-R-P, and it stands for Controlled Application Review and Resolution Program, when the DHS and the USCIS began giving extra scrutiny to immigrants and non-immigrants from, and listen to this, from Arab, Middle Eastern, Muslim, and South Asian communities when they applied for US citizenship, lawful permanent residency, and asylum. The ACLU brought legal actions against this program because it was unjust. Well, unjust does not mean unlawful.
Look, 2 points. One, none of the arguments that I have made made any arguments against the humanitarian consequences of the law. The only part of the reason I brought it up with the fact that it was discriminatory was to prove that it has impacts on Muslims, a violation of the Equal Protection Clause, which is part of the 14th Amendment, which is part of the U.S. Constitution. The U.S. Constitution is the supreme law, to use the wording of the resolution, law of the land. I pointed out how it violated familial relationships, which are part of privacy, which have been interpreted by the Supreme Court. It's part of freedom of religion. It's part of the First Amendment. Okay, these arguments are relevant to what I'm saying. Second of all, you're ignoring my argument that you look at these words in the law and you read them one way, that the president has absolute authority. But when courts look at a law, they don't just look at the law in a vacuum. Okay, the courts look at a law saying, okay, if this law changed another law, why did that change occur? Right? Because the purpose of it was to ban discrimination based on national origin. That's why the purpose of the law was. It's clearly identified in the history of the legislation, which courts look to when determining the meaning of laws. They don't just take words and evaluate them in a vacuum. Second of all, the Congress, even if the Congress did this would be your interpretation would be unconstitutional, because the Congress can't pass unconstitutional laws. It can't just give the president power that the president doesn't have under the Constitution. That's a violation of the Constitution. This has been established in many Supreme Court cases. So that's another reason why you cannot look interpretations of the law. And look, also, you kind of keep saying, well, this is just clear, this is obvious. If it was just so clear and obvious, Trump wouldn't have lost all but one of the court cases. He's lost all but one of them. So it's not clear. It's not in any way clear. So the question becomes, what do those words mean, and why are they there? Right? They are there. The Immigration Nationality Act of 1968 is there to make the changes, because the Immigration Nationality Act of the 50s blocked discrimination or blocked entry based on national origin. And that's why it is unconstitutional. And now your argument about Obama's Iraq program, okay, and that it didn't suspend everyone from Iraq. It didn't do it based on a whole bunch of countries. It wasn't, you can't prove that it was driven by animus, which I made a lot of arguments in my first speech about how this law was driven by animus that haven't been responded to in any ways. And if it is exactly the same, the fact that it didn't make it out all the way through the courts, it was the same as this, I would agree that was unconstitutional as well. The fact it didn't exist on the books long enough to ever make it through the court system, and like you said, nobody kind of knew about it, and it was just a change in the vetting procedure. So it's not the same exact law. I think the weakness of your argument is you just kind of keep trying to look at these certain words and your interpretation of them and how you think it's so obvious, but no court at the very least agrees with you. It is.
No, there's no interpretation on my part at all. First of all, because it hasn't been deemed unconstitutional, and I'm not trying to prove that it is constitutional, because it has to be decided by the court, which the court doesn't even have right now the authority to review the presidential decision. But it's a chief executive decision to protect national security in times of great confusion and chaos right now around the world. The courts have almost no authority to review presidential decisions when those are done to control who may enter the country, and no authority to do so when immigration is limited for national security purposes. And this is what the travel ban is about. And once again, I'm strictly arguing the legality of the ban. Whether or not it's constitutional, it will eventually be brought to the court. But guess what? The court doesn't want to bring it up. The Supreme Court ends next week. That case will not go to the Supreme Court. They will be in recess, and they will reconvene the first week of October. By then, the travel ban will be like null and void. The whole time that travel ban was initiated in January, then again in March, we're right in it. It expired June 14 already. So now Trump did addendum, and that will push it through September. By then, even if the court wants to hear it in October, it will be moot. So there's no argument behind the constitutionality of the act. What I'm arguing the topic, which is the legality, and Donald Trump's travel ban is legal and lawful based on the statutes of the law authorizing him to do so in the writing.
I guess I just make a few informational points. The one is that the Supreme Court, all courts can review the decision. The Fourth Circuit, the Ninth Circuit, okay, all courts thought this was a justifiable issue to bring before the courts because they say that the president's power and national security issues, even those related to immigration, while high, are not absolute, which means the subject matter is reviewable. It's been reviewed by the initial the courts, the circuit courts. It's been reviewed by the appeals court. Okay, whether or not the Supreme Court will take it up is an open question, right? We don't know if they will decide to take up this case, but they're considering taking up this case, and most people say they will take up the case. They will probably take it up in the fall. All right, because you're right. The term's coming to an end, so it'll take it up in the fall. Whether or not the ban becomes a moot question or not, okay, it's not just related to whether or not it's constitutional. It's related to whether or not the president has the time to institute the vetting procedures. But he probably wants his case to go before the court, so we can just kind of extend the need for vetting of the procedures to get it heard. But those are kind of separate questions. The other question that's separate is that whether or not the court can decide to take it for two different reasons, either because it's unconstitutional, all right, or because it's a violation of legislation, or a combination of the two, right? It could hear arguments on the Immigration Act, it could hear arguments related to constitutionality, and they could hear arguments related to international law. Determining whether or not it's unlawful involves assessing all three of those. A law is not just the Immigration and Nationality Act. The law is the Constitution. The Constitution, as I pointed out in Article 6, is the supreme quote-unquote law of the land. So if I win that it violates the Constitution, it is unlawful, even if it's consistent with the Immigration and Nationality Act. I made arguments that it's inconsistent with the International Convention of Civil Discrimination, which we have ratified as part of our law that you haven't responded to. So if I win that argument, I also win that it's unlawful. Even if you win all your arguments about the Immigration and Nationality Act, it's still illegal. Those are still laws. But I've defended over and over again the distinction between what you're making, that you keep just saying it's an obvious. It's obvious to you, yes, because you're not looking at back at the history of the act. You're not looking at how those words have been interpreted by other courts. You're not looking at the fact that every court has said the president does not have absolute power, no matter what Congress says. You haven't answered my argument that the Congress can't delegate unconstitutional power to the president. So, I mean, you just keep saying it's just so obvious, but you have to look at words in context, in legal context, based on the intention of Congress when they passed the legislation as articulated in the hearings and what was said about it, and how the courts have interpreted those words in the past, and how presidential power has been interpreted in the past, not just what a sentence says on paper.
Hey, I don't know if it was the last term. I can tell it's a very heated debate and arguments. The thing is, and it will need to be put up to review at this point, you keep bringing the Constitution into this debate, and we agreed in the previous post that the constitutionality of the travel ban was not to be debated. It is not in the topic. Okay, so right there, all the arguments that you've been made about the constitutionality are not up to debate. It's strictly on statute. Granted, yes, there's a circuit court that debate on that, the Ninth Circuit Court, for the statutory purpose. The Fourth Circuit Court is debating on the constitutionality. So we just took that out of the debate. So we only have to prove one thing: the legality on the statute, whether or not the travel ban is lawful. And I've proved my case that Trump's travel ban is not unlawful. So once again, is it the right thing to do morally or ethically? It's not the question. It might be wrong in view of many current events and circumstances, but this is not a debate about political ethics and morals. We must look at it solely through the eyes of the law, and the travel ban is not unlawful. So that I think that concludes my my part here.
Okay, good debate. Quickly, one, I never made arguments about why it was immoral. Well, I think I'm winning the immigration nationality debate independent of the constitutionality argument, because I've explained why you have to interpret those words in context and why my interpretation is better. Also, even independent of the constitutionality, didn't really respond to my international law arguments, so those become incorporated into U.S. law.
What happened?